To begin, we're going to have Professor Bowman's going to give a brief introduction on the impeachment process.
Okay, I'm going to take you in about 5 minutes through about 400 years. Okay, so saddle up. Here we go. Impeachment was invented by the British, specifically by the British Parliament, and essentially it was invented because of the ongoing tension between the king or queen and the group of interests that were represented in Parliament, sometimes opposed to the king or queen. That's to say, the hereditary aristocracy, the landed gentry, the princes of the church, and others. And there was constant tension between Parliament and the Crown, largely based on the tendency of the Crown to seek to move towards autocracy and the desire of the other interests of society to counterbalance that. And of course, one of the troubles with having an hereditary king is that you can't easily depose him without slapping on your chainmail and going off and having a bloody revolution. So one of the things that Parliament figured out was that they could at least slow down or impede particularly noxious royal policies by impeaching or removing the ministers of the crown. And the way they did it was a model that we have become quite familiar with. That is to say, the lower house of Parliament investigated and then decided if they were going to impeach someone. If they did, they swore out or decided on articles of impeachment, just as we do here in the United States. Then people who, even in those days, were referred to as the House managers, walked over to the House of Lords and said, "Hi, we're impeaching Lord so-and-so." And there would be a trial in the House of Lords, and there would be a decision. Now, a couple of things about that basic model. I said at the outset, of course, that this was, impeachment was actually used. I'm oversimplifying massively. Impeachment was used for a lot of things, and not always for high-minded ones. But if we confine ourselves to this basic fight between the Crown and the interests of Parliament, this is certainly a central theme. But one of the attributes of being convicted, if you were impeached and then convicted by the House of Lords. Here's the impeachment of Lord Strafford in 1641. But one of the problems with losing, if you were a lord or somebody else who was impeached at that point, is that the consequences could be rather ghastly. You could, in fact, lose your head, or worse yet, be drawn and quartered before they chopped off your head. So in that sense, parliamentary impeachment was very different than what we know today. It was criminal in the sense that it had criminal penalties associated with it if you lost. But in many other ways, it was quite similar to what we know today. Now, the other thing that we inherit, other than the basic pattern from Parliament, is some basic understanding about the kinds of things that are deemed to be impeachable. Over time, impeachment or the Parliament impeached people for a whole bunch of different stuff. But they never passed any kind of statute, and of course they don't have a written constitution that said, well, these are the kinds of things for which you can be impeached. Rather, over time, and using essentially a kind of common law method of doing it, there grew to be a group, categories of things that have sort of been traditionally impeachable. And beginning in 1386, they sometimes, though not always, used a very interesting phrase to categorize the things that they'd called impeachable. High crimes and misdemeanors, that's where we get that phrase. It's essentially a term of art that comes from British practice. Now, it turns out, and very few people know this, that not only did we inherit impeachment from the British, but for a long period of time on this side of the Atlantic, in British North America, impeachments occurred both in the colonies and between 1776 and 1787, there were 12 states that had written constitutions. 10 of them had impeachment provisions. And so there were, in fact, there was a history of impeachment over on this side of the Atlantic. In particular, a particular one which I'll point out to you was the impeachment of Justice Peter Oliver in Massachusetts in 1774. In essence, Justice Oliver was impeached by the Colonial Assembly for the grave sin of deciding to accept a royal salary as decreed by Parliament instead of simply taking the salary that the Massachusetts Assembly had decided to give judges. The colonists thought this was terrible because it essentially threatened to remove any control they had over local judges and essentially cede it to Parliament. And so they impeached him for this, and they called his choice to accept a royal salary as decreed by the king in Parliament tantamount to bribery, and they characterized it as high crimes and misdemeanors. Then we get to the Constitutional Convention, of course, in Philadelphia in 1787. And we could spend hours talking about that, but we don't want to do that to start with. Let me just point out the results of what the framers did. First of all, what they did, of course, is they decided that there would be impeachments and that the president in particular would be impeachable. There was considerable debate about whether or not that should happen at all. Many of the framers thought, we got elections. We don't really need to have the special impeachment thing. And what's more, many of them thought the presidency would be such a weak office in comparison to the Congress that they really didn't need impeachment at all either. But in the end, the people who decided that impeachment was an essential part of sort of Republican government decided that we would have impeachment, and they wrote it into the Constitution. And here, very quickly, is what they did. First of all, of course, they said that the House shall have the sole power of impeachment. They also cast the power of trying impeachments to the Senate. And critically, of course, they said that nobody can be convicted in the Senate without the concurrence of 2/3 of the members present, which is in some ways perhaps the most important provision regarding impeachment in the whole darn Constitution. Finally, or not quite finally, but this point is really important here, terribly important, and it's one that I think is often missed. The framers were quite well aware of the bloody history of impeachment in Parliament. They did not want to have an impeachment process that could produce criminal and oftentimes capital consequences. They wanted to ensure that impeachment was a purely political remedy for the political problem of a misperforming or perhaps overreaching or indeed potentially tyrannical president or other civil officer. And therefore, they made sure that the only penalties that are available if you're convicted by the Senate after being impeached are loss of office and, at least under current practice, if the Senate takes an additional vote, you can be essentially disqualified from any future federal office holding. And the final point, of course, is, come here, you little rascal, the final point is this. The framers might have done, as Parliament had done for 400 years, and not defined the reach of impeachable conduct at all. But they were in love with written constitutions and writing things down and defining them, and decided they needed a definition. In September of 1787, as the convention was drawing to a close, the form of words that they had pretty much brought it down to was only treason and bribery. But George Mason of Virginia decided that that was insufficient, and he proposed first maladministration be added. James Madison decided that that was too broad and said so. And then Mason came back with this alternative, the good old British term of art, high crimes and misdemeanors. And that's what we have to this very day. So that's enough of an introduction to get things rolling. I'll stop there.
Thank you, Professor. What a quick 400 years of history there. We're next going to move on to a specific question that each panelist is going to answer, and then we're going to open it up generally for questions from the audience. So first, starting with Professor Victoria Nourse, your question is, how is Congress's investigative power affected by the actions the Trump administration has taken to combat the impeachment inquiry?
Okay. Well, thank you all for having me. I have been following the subpoena cases that have been going on before the impeachment, and that's what I want to talk about a little bit. How this will actually play out is a moment-by-moment Washington drama that no one can predict. I will give you some of my general thoughts about the cases that are in the court, and then I'll make a couple of comments based on my experience when I first got here as the baby lawyer on the Iran-Contra investigation and in my work in the Senate in general. So let's talk about the cases. So the president has been subpoenaed, and many people have been subpoenaed within the executive branch, but the president has also been requested to use his tax returns and his various other financial information. So there are a number of cases that are currently pending in the courts. And Professor Chafetz, who's actually the expert on this, since he wrote a very fine chapter about the history of this, knows, as the rest of the panelists do, is that the law is really pretty clear, that the president's arguments are not very good. Basically, they are arguing that Congress has no power to regulate the presidency, which is considered by the House counsel to be, quote unquote, astounding. That's a word from his own brief in one of the cases. Congress's subpoena power is broad, it's extensive, it's far-reaching. Those are words from the Supreme Court cases. So we've had subpoena cases going back to, I don't know when. The law has been pretty clear that Congress has subpoena power. The only question is whether the president himself can exert executive privilege over any particular thing, and that's really pretty narrow. The courts themselves have claimed they have the power to decide executive privilege. But in general, I had predicted, I think, about 7 months ago, that these cases would fail on the law. So we've seen 4 courts already conclude that the various things that the administration is supposed to provide, their arguments are not good enough. We've seen them in cases here in D.C., and they do differ. There are some cases that might say, for example, testimony of Don McGahn, his own lawyer, which might be different for various reasons. I don't want to get into any of the technicalities because you want to know how this affects the impeachment, and that's the $64,000 question. Now, it appears from today's news that the self-impeachment continues. Which is to say that the administration, rather than fight subpoenas, I mean, they basically admitted a quid pro quo, or at least a conversation regarding investigations into one of the major political opponents of the president as a quid pro quo for a meeting or further favors from the United States, and that included withholding money, which, by the way, under other federal statutes must be spent on that item, cannot be diverted for personal political aims or any political aim. I spent a lot of time when working in the White House making sure that every second was accounted for so that we knew what was on the public side and what was on the private side. So, for example, if you want to have water for Beau Biden's funeral, you can't accept any free water. You can't spend any public money. You have to figure out some way to do it legally. So there are lots of restrictions on how you can actually spend congressional money. So the self-impeachment continues. And so what's fascinating is that that's taking place in the press. Meanwhile, all of the testimony is being taken in camera, as far as I can figure out. Am I correct on that, panelists? Yeah. Now, this is in part because there's classified information, and so they're doing it in a SCIF, which is a secure classified, they used to put us in things that look like, large dryers, but now I'm sure it looks better. But so that no one can listen in. And
Of silence.
Yeah.
Remember that?
Cone of
Cone
silence.
from
Yeah.
Maxwell Smart.
Well, unfortunately, John Poindexter smoked cigars all the time, and we were in this thing that was like tiny, and I was like, can I please get out of here and breathe? So anyway, I digress. So things have improved on the SCIF side of it, the secure facility side, and I actually think that that's a wise thing to do. I think undertaking any trial in the press is very difficult to do. And the way in which the media can portray any of it has an enormous impact that may not really comport with the evidence. From my experience, I'll just explain that you're all way too young for this, but so that was when there were only 3 networks, but they opposed my boss, Arthur Lyman, and Ollie North's picture, frame by frame, against each other. And my boss was not the most attractive person, and Ollie's very attractive. And later studies showed that had an influence on what people thought about Iran-Contra. So, meanwhile, no one knew that we were getting bomb threats. He was threatened this is before they had a lot of security. So, boy, am I dating myself. So, he asked all the people, do you want to leave? Because there could be a shooter in the audience. And so we all said no, because they had come with the dogs and we figured all the weapons were gone. And, I remember because I was looking for the documents, so I'd, document 4223. So I'd be like, I just hid a lot more. But it was a scary thing. But none of that was really told, the media portrayal of things can be very, very different from the story you see from the documents. You'll learn this if you ever do a trial. Also, very different what the jury hears and what you know from your documents. So one of the things that I think is smart that they're doing, if you want to make a case for impeachment, is to do this in not the most open way, to get the story in depositions first, which is what good lawyers do. They do it before trial as well. You don't ask a question you don't know the answer to. Then come up with some kind of procedure to present that to the public in a way that is easy for them to digest and understand. We lawyers spend a lot of time worrying about high crimes and misdemeanors, but having worked both in the political sphere and also in law, I'll tell you that they're very different. And, if there is going to be a case made for impeachment, the Chairman Schiff understands that as well, and he'll have to be able to condense it to Twitter-sized space, I expect. And that's a bit unfortunate. But that is sort of the reality of it. And it can be done. I mean, in my view, no one remembers this, but someone stole a missile during Iran-Contra, and then there was profits in a Swiss bank account. I call that theft, and yet we took years and years and years to investigate what happened and whether it was a violation of the Boland Amendment. So the final lesson, if I'm going to give you anything about watching this unfold, is that you have to look at two different stories. You have to look at the legal story with your law degree and read Frank's great book here and learn everything about high crimes and misdemeanors. Also buy the Chafetz book over there if you want to know how Congress's other powers work. But you also have to, as a consumer, be somewhat critical of the sort of media framing of events. Okay, so if you really want to know the truth, click on the documents, read the documents yourself. Be a good consumer of what you are hearing on Twitter. Thank you.
Thank you. Next, with Professor Chafetz, procedurally, what are some points in the impeachment process that could go awry?
Well, thanks. Thank you so much for having me. And this is going to pick up, I think, on some of the points that Professor Nourse was just mentioning. And it's also going to do something that's just setting a terrible example for all of you, which is I'm just going to fight the hypo here. I think the most, in some sense, the procedural point that should most clearly be kept in mind is that if you're thinking in terms of procedure, you're doing it entirely wrong. So every sort of bit of legal training, right, that people have tells you, well, what you do when you have something that looks like a legal standard, right, treason, bribery, or other high crimes and misdemeanors, and you have someone accused of violating that legal standard, is you sort of take the legal standard in one hand, you try to flesh it out, you look for precedents like the ones that Professor Bowman mentions in his book, you try to sort of come up with an architecture of what constitutes a high crime or misdemeanor, then you take the facts in the other hand, you see if it fits the mold, and bam, you either have someone who's committed high crimes and misdemeanors or someone who hasn't, right? I think that's exactly the wrong way to think about impeachment, because at the end of the day, the question in an impeachment proceeding should not be understood as, has this person committed high crimes and misdemeanors, but rather, is there the political will there to remove this person from office? Or to put differently, should Donald Trump remain president of the United States? That's actually the question that's being asked. Now, it's being framed in certain very important ways by the Constitution, right? So Professor Bowman pointed out not just the sort of thing that looks like a legal standard, but also, really importantly, the 2/3 bar for conviction, right? So that tells you what your burden of persuasion is going to be, right? You're going to have to convince at least 2/3 of the Senate that Donald Trump is not deserving of remaining president. But that's ultimately the way it should be thought of. And that, I think, has some really important implications for how both houses of Congress ought to be moving forward in a proceeding like this, right? It has important implications for how you go about convincing members of the House, members of the Senate, and perhaps most importantly of all, and this is where it ties into what Professor Nourse was just talking about, members of the public as well. Because ultimately, whether or not the Senate convicts Trump, and it seems, so I'll just put my cards on. I'm assuming the House will impeach Trump, because if the House didn't have the votes and the will to impeach Trump, Pelosi would never have come out in favor of opening an impeachment proceeding. So let's just take as given the House is probably going to impeach Trump. And so then the question is, what does the Senate do? And ultimately, that means that proceedings in both the House and the Senate are going to have to be aimed at, A, winning over either some number of Republican senators. And the only way you're going to do that is by winning over a large number of political independents in the public at large, and at least a decent chunk of Republicans in the public at large. And you can see this happening, for example, during Watergate. If you look at the sort of polling taken throughout Watergate, it basically is the case that at different points you can see a fairly tight correlation between what's going on in both the Senate Select Committee and then later the House Judiciary Committee and what the public polling looks like. And it's as sort of independents and then a few Republicans start to turn that impeachment picks up momentum and that Nixon ultimately winds up resigning. So what ultimately this means going forward is that the way that both people in the House and then eventually people in the Senate should be thinking about structuring these proceedings is not technical demonstrations of, Trump has done these things that violate what we understand to be the standards surrounding high crimes and misdemeanors, but rather they should be thinking in terms of performing his unfitness for the office. Right? That is to say, playing to the cameras, playing to the galleries, playing to social media, and saying, look, here's how you can understand what he has done. Here's how it fits a coherent narrative, and a narrative aimed to convince you not just that he's done something illegal, but that he's unfit for office. Right? And that means sort of structuring your arguments in a certain way, structuring them to be easily digestible, but also structuring them around certain sort of narrative frames, right? Picking one or two points and trying to relate as much as possible to those points. Thinking too much in terms of procedure, thinking too much in terms of making procedural arguments or making arguments sounding in legal standards, if you hear the Democrats doing that, that means they're losing. Right? At the point at which they're doing that, they may be doing things designed to appeal to lawyers, but it turns out that what appeals to lawyers actually turns off a lot of other Americans. So yeah, congratulations, your law school tuition will make you highly unlikable. To the extent that they are making lawyerly arguments, they're not going to come out ahead here, right? That what they need to be doing, again, is aiming at showing his fundamental unfitness for office. And one of the ways that this has played out in recent weeks, right, is and I think this gives you a sense of who's currently winning the politics of it, because it's actually the White House right now that's trying to make procedural arguments, right? So we've seen the argument that there needs to be a resolution in the House structuring the impeachment inquiry, and until there's a resolution passed by the House, there isn't a real impeachment inquiry. That's nonsense, right? So the first presidential impeachment in American history, Andrew Johnson is impeached in 1868. He's impeached 3 days after he fires his Secretary of War, Edwin Stanton. It's 5 days after, my students here are laughing because we just covered this last week. It's 5 days after the House impeaches him before they actually pass out even any articles of impeachment, right? So they basically say, like, we impeach thee, and then we're going to come up with some reasons, and they do. So the idea that you have, and even more recently, going back into, you only have to go back to the 1980s to find judicial impeachments that did not start out with a resolution of the House structuring the proceedings. So the Alcee Hastings impeachment, for example, doesn't start out with a resolution in the House structuring it. But you can see why there's a sort of attempt on the part of the White House and its defenders to sort of derail this political process by raising procedural objections, right? To the extent that we're thinking in those terms, and rather than in thinking in terms of who is fit for office, we are essentially saying this is not going to end in removal. And by the way, removal can be one of two things here, and this is just what I'll end with. Removal can either be conviction in the Senate, or removal can be the outcome of the 2020 presidential election, right? So the fact that all of this has to go through the public, whether it's a matter of getting Republican senators on board, which is only going to happen after the public opinion turns, or whether it's a matter of simply having a Democrat win the 2020 elections, either way, it's going to have to go through the public, and therefore the audience for all of these performances has to be understood as the American public. Thanks.
Thank you. The next question is for Professor Susan Bloch. How does this impeachment process compare to that of President Clinton and Nixon?
I'm going to stand. I'm trying to stand. Okay. Sorry, I don't mean to be formal, but it's... So how does this impeachment, if it goes forward, differ from Clinton and Nixon? A couple things. Substantively, Clinton was accused of lying about his sexual relations with an intern. and lying to a grand jury. But it was basically different from what Nixon was and Trump is being accused of, and that is abusing their presidential powers to influence an election. And so while you can couch the offense of each of these guys somewhat similarly, I think the public, and as Josh pointed out, this whole process does have to convince the public that this person should be out of office. The public, I think, didn't take what Clinton did as seriously as they took what Nixon was accused of doing and what Trump is now being accused of doing. So I think substantively they are quite different. Procedurally, as Josh pointed out, there's a difference too in that we haven't had, in this case, in the Trump case, a official House vote to initiate the impeachment inquiry. Trump, as Josh said, is making a big deal of that, but most observers, and I think that includes all of us up here, don't think that you have to have a full House vote. And obviously what happened in this case is Pelosi just announced the inquiry. In prior administrations and prior impeachments, you often needed a House vote to give the House some more powers. But the current rules don't really, under the current rules, the House can take depositions, can issue subpoenas without having an official House inquiry vote. So there's probably not much to the Trump administration's argument that this inquiry is somehow illegitimate. Nonetheless, that is one way in which the current proceeding does differ from at least the Clinton and I think the Nixon. And conceivably, it could matter if we get down to the point where the Trump administration is refusing to do things and the House has to go to court to convince the court that their interest in whatever the desired material is so important that the court has to order the Trump administration, to turn it over. That's a balancing test that you'll either have learned about or will learn about in your con law class about the United States versus Nixon. And on that balance, I could see a court saying, well, there hasn't been an official vote to start the inquiry, and maybe therefore give that side, the House side, a little less weight. But that's just conjecture, and I think if I had to put money on whether not having a House vote is going to matter, I would put money on the side of saying it doesn't matter. But anyway, it's a difference. I was told to talk about the differences, and that's the difference. I think one of the most significant differences between this impeachment and the prior ones is this one is not based on a prior special counsel report. Nixon, we had the Cox/Jaworski report. You all remember in Clinton, we had the 400-page Starr report. In the Trump administration right now, we do have the Mueller report, but he didn't address anything about, as far as I know, about the Ukraine affair. So as a result, the House is having to do all its own investigation on that matter. And we have 6 different House committees doing it. And that's a significant difference. How much it'll matter in the final analysis, I sort of doubt that it will. But it is making what we're watching very different, and it's sort of the drip, drip, drip of everyday revelations about what was said in which committee, and that we didn't really have in the prior Nixon and Clinton matters. And finally, and I think this is really important, both Clinton and Nixon faced the impeachment in their second terms, and there was no new election coming up. This obviously is quite different because we're in the middle of pre-election time. We've got the debates going on in the Democratic Party, and people are thinking about the re-election of Trump. And so it's sort of tempting, I think, for people to say, well, why go through this whole impeachment thing? We've got this election coming up, and let the people decide, because after all, that is impeachment is a way of getting rid of a president in the middle of the term when you don't have the ability to vote him out of office because the election's too far away. And I'm sure there are people saying that. And I know there are people saying that. I've heard them. And that is tempting, but I think that the framers did discuss this. They said, well, do we even need to have the power to impeach the president? It's only a 4-year term, and the elections come up, and you can vote him out of office. But the framers said, no, we still need this power, because if the person's misusing their office, we got to at least give the House and the Senate the opportunity to get rid of him. So, but again, that's a big difference between Clinton and Nixon, where they were in their second term. One last point, and I made this when I was testifying and working on the Clinton, against the Clinton impeachment, really. I think it's really important to remember that the impeachment power, the whole process, is not to be used to reprimand or to issue a scarlet letter that's to say we disapprove of what you did. It is a drastic remedy to remove someone, in this case the president, from office, a duly elected person. I guess the duly in this part could be questioned, but that's another topic. But it's a drastic remedy to remove a duly elected president from office. It is. So the thing that I totally objected to and still get annoyed with is there were members of the House during the Clinton impeachment. There were members of the House who said, I'm voting for impeachment, but I don't think he should be convicted. I hope the Senate does not convict him, and implying in their statement that they would not vote to convict, but they wanted to impeach. And that I think is wrong. I mean, I think that you vote to impeach if you believe this person should be removed from office. And sort of, therefore, you hope that the Senate will remove. Obviously, you, as a House member, you can't control what the Senate does. But I believe that, and there may be people who differ with me, and I welcome the debate. But it's my opinion that this impeachment remedy is a drastic remedy. It does undo an election in the sense that you get the vice president, so it doesn't totally undo the election, but it does remove from the presidency the person that we all elected, or a majority of the electoral college elected. It removes that person from office, and therefore, as a drastic remedy, you only do it if you believe the Senate should convict. Again, I'm not saying that the Senate will, but you should not vote as a House member to impeach and then hope that the Senate doesn't convict, in my opinion. Okay, that's how this impeachment process that we're watching differs and is or similar to the Clinton. It's substantially different in my view.
Thank you. Finally, before we open it up to questions, for Professor Bowman, does President Trump's actions with Ukraine, China, Australia, and I guess today with awarding himself the G7 summit constitute high crimes and misdemeanors?
Before I get to that question, I'm going to just touch very quickly on a couple of points that the other distinguished panelists have made. First, with respect to the business about the argument that there has to be a full House vote before there's a real impeachment. I agree with everybody up here. I think that that's complete nonsense. And one way of illustrating the absurdity of it is to simply recall that impeachment is only one of the many powers that are given the House and the Senate, and the two of them acting together by the Constitution. The House has the power of initiating essentially revenue bills. The two houses together have the power to regulate interstate commerce and create post offices and all that sort of thing. The idea that you have to, and in order to do all of those things, both houses of Congress have to collect information. They do it in various ways, sometimes through compulsion, sometimes by invitation, but you have to collect information. And that's really what an impeachment inquiry is. It's collecting information. So the argument that you can't have an impeachment inquiry and that the House can't exercise that particular constitutional power without a full vote is rather like saying that the House can't collect information to pass an agriculture bill or even to think in committee about passing an agricultural bill unless we have a full vote of the House every time the House wants to exercise one of its constitutional powers. That's just absurd. So I think that's nonsense. I agree that some court might latch onto it in a balancing test, but I think it's constitutionally silly. I certainly agree with Josh that in the end, any impeachment is at bottom an effort to convince both the legislature and the public whom they represent that the president is unfit to remain in office, that he either has lost his personal legitimacy or his continuance in office represents a threat to the constitutional order. I think that's absolutely right. You have to tell that tale, and you have to make that tale convincing. That said, I would perhaps disagree, or at least in emphasis, a little bit with Josh on this point. We got this language. It says you can't be removed unless you've committed treason, bribery, or other high crimes and misdemeanors. And therefore, in every case, the defenders of the president will look at that language and they will try to use it to defend their guy. And if you want, the first thing you have to do before, I think, or as part of making the larger case that he's unfit, is explain to at least those who are willing to listen what this phrase means. Because if you don't, then this phrase stands as an almost insuperable barrier to convincing a lot of people. For example, it looks like in order to remove somebody from office, you have to conclude that they committed a crime. Simply not true. 600 or 700 years of Anglo-American history tell us that that's not what that phrase means. But you have to at least be prepared to explain to those who are willing to listen, in and outside of the Congress, what it really does mean and why it doesn't mean what it seems to mean. In the end, I do think the constitutional language matters, and the collective understanding of the constitutional language matters because, and I think this is true, it was very true in Clinton, there was a long argument in which I played a very minor role, much less than some other people up here, in defining what high crimes and misdemeanors meant in the Clinton context. But I would say at the end, the consensus that emerged out of that argument set the ground rules on which the debate about whether or not Clinton should be removed was played. And without that debate, then you really are not going to be able to get to the more performative aspect of explaining why this person should not remain in office. So let me now tell you the story about why he shouldn't. Since impeachment was first invented in the 14th century, one of the principal reasons for which people can be impeached and removed is abuse of power. When we say that, that necessarily implies that we're speaking of an official who is granted by the Constitution or statute or some other authority legitimate powers to exercise on behalf of the kingdom, the Commonwealth, the United States. But abuse of power is to take the powers that you're legitimately granted and use them for illegitimate purposes. And when the powers are used sufficiently illegitimately and sufficiently to the disadvantage of the collective good, then that's abuse of power on a constitutional scale, and you need to be removed, or at least you should be. What do we have with respect to Mr. Trump? Well, of course, we have a lot of things daily with Mr. Trump. But the thing ultimately that seems clearly is going to get him impeached is what's happening what happened with Ukraine. And most of you, if you're here, I'm sure you understand that. But I think a couple points have to be emphasized. First of all, what were the legitimate powers that Mr. Trump was exercising? He was exercising, first of all, his commander-in-chief power, broadly construed, essentially over military affairs of the United States, including expenditures, allocation of resources, allocation of forces. He was using his power as essentially the chief diplomat of the United States. in dealing with the European Union, dealing with European powers in general, and dealing, of course, in particular with Ukraine. And how did he use these powers? Well, he used them in connection with the Ukraine. Where is the Ukraine, and what is it? I'm sure most of you know, but it bears repeating. The Ukraine is, of course, a former component of the Soviet Union, a component which Vladimir Putin and, frankly, many Russians would like to get back, either territorially, at least in terms of political control. And Russia has taken overt and violent steps in order to accomplish exactly that end. They've already annexed Crimea illegally. They are currently funding an ongoing rebellion, if we can call it that, certainly an insurrection in the eastern part of the country. They're using all of their political and military power to bring the Ukraine essentially back into their orbit. And therefore, the Ukraine is a country which, among other things, when it is approached by the President of the United States, is not a peer. It is not, and the President of that country is not a peer in any meaningful sense. They are a country that is on the verge of being absorbed back into the Russian orbit, whose political and indeed territorial independence teeters on a knife edge. And the President of the United States says to the President of the Ukraine, here's all the things that we do for you, but you know, what we're doing for you, it's not quite, and this is his word, reciprocal. But what's the reciprocity he wants? A couple of passages later in that conversation, the reciprocity he wants is investigation by the Ukraine, first of all, this absurd conspiracy theory that somehow or other Hillary Clinton's email server is secreted away in the Ukraine, which leads you to wonder whether Mr. Trump is entirely compos mentis on top of any other consideration. But more importantly, the thing he wants is an investigation into his possible presidential opponent. And despite the absurd claim that there was no quid pro quo, a phrase, frankly, I'm not entirely sure Mr. Trump knew before some lawyer doubtless told it to him. Of course there was a quid pro quo. That's exactly what he was demanding. He was talking about reciprocity. And so what we have is the President of the United States invoking and marshaling all of the vast powers of this country, the greatest and strongest country in the world, because we still are, against a country teetering on the brink of losing its independence, and saying to the president of that country, either you give me what I want for my private purpose of securing my reelection, or I'm going to withhold the aid that keeps you free. Now, if that's not an abuse of power, ladies and gentlemen, I've never heard of one.
Thank you. And we're now going to open it up to questions. If anybody has a question, you want to go? We're going to walk the mic to everyone so that they can be heard.
Test. Is it working? Okay.
So I would probably agree with you that it seems likely the House will actually impeach President Trump. From there, is it as likely that McConnell will actually hold a trial? From what I remember of U.S. v. Walter Nixon, which is admittedly probably not as much as anyone up there, the Senate has a lot of discretion in what constitutes a actual impeachment trial. So is there any possibility that Mitch McConnell will basically throw up his middle finger and say, here's your trial?
No.
He will actually hold a trial?
He'll hold a trial because he may not. It wouldn't be his optimal outcome, but he'll hold a trial because Cory Gardner and Susan Collins and Joni Ernst and people running. Let's see, whoever's going to ultimately win the Republican primary for the Georgia Senate seats, and every even remotely vulnerable Republican will demand that he. And then some who aren't vulnerable, who are just increasingly annoyed with Trump, like Mitt Romney, I can't see doing that. And ultimately, a Senate Majority Leader's power comes from his ability to hold his caucus together, and that's about it.
And I should add, by the way, that although obviously we know that Senator Majority Leader McConnell is not necessarily a man who always adheres to the rules. In fact, there are Senate rules that it would be very hard to get around that seem to decree that some kind of proceeding, at least, must occur once an impeachment has been transferred to the Senate. Now, you're right. The Walter Nixon case suggests that there's an almost infinite degree of flexibility about what the trial would look like. But I think the combination of the existing rules and the fact McConnell has actually said that he thinks he's got to have a trial. I think it's going to happen. What form it takes, another question.
You have to remember that the under Article 1, the House and the Senate have the power to create the rules of their own proceedings, okay? And what's going to happen in terms of the Senate is if they would have a huge fight. If he tried to avoid his own rules, that would be a reason for the other side to fight and make this blow up. And so that's why he has already stated he'll have to follow the rules, because he doesn't want to have that fight for the reasons that Josh said. Will the trial be long? No. Right? But the outer boundaries of what he can do are not set by the Constitution. They're basically set by the internal and external politics.
And one other little point is that if we're impeaching and trying a president, it's the Chief Justice of the Supreme Court presides. And once he comes down to do it, I don't think McConnell, I think, has, I suppose, the ability to try and not to even start the trial and violate his own rule, the Senate's rules. But once the Chief Justice is there, I don't think McConnell can stop him.
Although it is worth noting just on that point, right, that in the Chief Justice's role as presiding officer of the Senate, he's like any other presiding officer. His rulings can be overturned by a bare majority of the Senate.
The Chief Justice's role is very odd. You would think he would get to be like a regular judge, but he's not. He's more like he's kind of a potted plant.
Yeah.
I mean, he calls things to order, but and I suppose he can make some rulings, and probably does, from the bench to sort of keep things moving along. But the Senate decides its own rules as it goes, on the fly.
Right, and he'll take messages from the parliamentarian about how to rule one way or another. So that's what the presiding officers do. They don't know what the rules are. The parliamentarian gives them little slips of paper, and then they. Anyway.
You can hope that he maybe goes back to the Rehnquist robe with the cool stripes.
Oh, no, Rehnquist donated that somewhere.
Oh, darn.
And he got a tax deduction. I'm writing a book that he's involved in. So, sorry.
Right over there.
Just gonna test out the mic really quick, making sure that we have a little bit louder. Is that louder? Okay.
Yeah.
Where's the mic? Oh.
Hi, thank you for this presentation. I think we can all agree that legitimacy is a very important issue, one of the bases of democracy. I come from Peru, where we had 3 impeachment processes in the last 2 years. And legitimacy was a huge issue that was being discussed in the press and in the streets and even in Congress. So yesterday, I heard 2 days ago in the debate a question saying that why would the Congress or the House go ahead with an impeachment with 2020 elections coming right now? And when I heard the presentation and you said that we should, or the House should, skip all the legal arguments and go with the unfitness to office argument, I was thinking about the polls and what the street is thinking right now about President Trump. And maybe there's a possibility that in 2020, President Trump would be reelected. So how would the House and the Senate manage to balance that legitimacy of, or apparent legitimacy of President Trump for 2020 elections and the impeachment process?
Well, my view is any world in which Trump gets reelected in 2020 is a world in which he's not going to be removed by the Senate before then, right? So the two are sort of deeply enmeshed, and I think that was sort of the point that I was trying to make. I think that I don't think that you can sort of hermetically separate these. I think one of the best answers to, why would you bother with impeachment if there's an election coming up is actually because impeachment is a really strong electoral argument, right? This is an opportunity, this is a focal political moment, right? The eyes of the nation are on the impeachment proceedings. It's happening with an election looming over us. And one way that the Democratic Party as a whole can get its arguments about why you shouldn't vote for Trump out there is through the process of the impeachment proceedings. So I think to try to sort of pull them apart and say, well, the impeachment proceedings are sort of quasi-legal and electoral politics is purely political, I just think that doesn't make a lot of sense to me. They're both completely shot through with politics, and we should think about them that way.
And there actually is a precedent for this situation. Andrew Johnson was impeached on February the 24th of 1868. That was an election year. Now, he had at least the potential of being elected again. He wanted very much to be elected again, although the party alignments in those days were a little fractured. And one of the considerations that went into whether to impeach him in the first place, and also whether he survived, had a lot to do with the fact that the election was coming. And, for example, he probably survived not so much because he didn't commit an impeachable offense, but time was short, and people went to him sort of privily and said, well, Andy, you're looking at impeachment, but if you promise us you'll behave yourself a little bit more, we won't vote to convict you. Or, there was also concern at that point that the person who would succeed him was undesirable to many of the Republicans. At that point, the person who would have been the successor was actually the president of the Senate, and the guy who was the president of the Senate at the time was a complete radical nut. He believed in stuff like, and you won't believe this, votes for women. And nobody wanted, some crazy guy like that in the presidency, even for a short period of time. And what's more, also, the Republicans had a ringer in the box for 1868. They knew they were going to nominate Ulysses S. Grant. And so all of these things weighed into the calculus of whether or not first to impeach him and then to convict him. And I think the shortness of his remaining tenure had something to do with the fact that he actually escapes conviction by one vote.
Hi, thank you very much for this very interesting presentation. I wonder if, in the context of changing or creating new procedural rules along the way, whether the Senate would have any possibility of creating or allowing people to vote anonymously. There is this sense of the fear of God knows what, but fear of death, it seems, that many Republicans face. Do you think that is a realistic solution for that?
I'll answer that.
No.
No.
I mean, it's both politically unfeasible, but also the Constitution specifies that one-fifth of the chamber can require a recorded vote for any vote. It doesn't specify that impeachment is an exception to that.
And I'd go even further than that. I mean, impeachment is by design a political process, but not only political in the partisan way, but political in the largest and most generous sense. In this sense, of course, Josh is absolutely right. When we're deciding whether or not we're going to impeach and remove a president, we are deciding something fundamental about not only the fitness of the president, this particular president, but we're deciding something fundamental about our constitutional future. And that is a vote that needs to be taken in public. The framers gave the Senate the power to try the case, understanding that this was a political body, responsible in the end to the electorate, although at that point more remotely because they were chosen by state legislatures essentially. But they gave it to those people rather than to judges, as they were thinking about, in part because they wanted this choice to be a politically accountable one. And as much as I make no secret of it, I despise Donald Trump and everything he stands for, and the danger that I think he presents to the American Republic. But at the end of the day, if he is to be removed, I think he has to be removed on the basis of a public and open vote. And people need people in the Senate need to accept responsibility for their choices.
Thank you. Thank you so much for the presentation. So my question is to Professor Chafetz. Yeah, I understand your point when you're saying that it should be more, it should be more about fitness than legal and procedural. But what about if you were defending? How would the office defend if not the legal and the procedural points? How would he say or present that I'm fit to be a president? How else would he? Yes, and if Professor Bloch can add, because you said that you were arguing against the impeachment of President Nixon, so if you had any insights from then. Sorry.
Clinton.
Sorry. Yes, President. Yes. Sorry, I'm so sorry, yes. So since then, if you had any, insight. Thank you.
Josh?
I think Clinton, the Clinton impeachment basically is the answer to that question, right? The response, yes, it sort of sounded in terms of these aren't high crimes or misdemeanors, but really the argument that was being made to the American public is you're going to remove him from office for this? Right, for lying about having sex with an intern in a grand jury deposition, grand jury proceeding, like, we don't even fine people for that most of the time. You're not, and it doesn't sound in the kind of large scale abuse of power that we're used to thinking of as as the kind of thing that's a high crime or misdemeanor, or that sort of ought to get people removed from office. So I think, at the end of the day, you might use the legal language, but essentially what you're arguing to the American people is this person doesn't deserve to be deprived of office for this. And I think we've had impeachments and convictions, or at least one impeachment and conviction, and one impeachment that should have been a conviction for things that it's hard to argue actually fall within treason, bribery, or other high crimes and misdemeanors. So the very first conviction in American history, Judge John Pickering, was basically convicted because he was drunk, a drunkard, he was mentally ill, and he occasionally blasphemed from the bench. That's actually in the articles of impeachment. Hard to argue that any of those are high crimes or misdemeanors, but he obviously shouldn't have been on the bench, and he was impeached and removed. And so I think, again, when there's a sense that someone is unfit for office, and I think the same thing with Andrew Johnson, by the way. He should have been removed from office. He came one vote shy. One thing Professor Bowman didn't mention is there's some evidence that actually at least one or two members were bribed to acquit him.
They weren't bribed until afterwards. Come on, man.
It's still a bribe if the payment doesn't come till later.
They didn't even demand payment till afterwards.
But I mean, the most persuasive article of impeachment, I think, against Johnson was the last article that basically accused him of going out of his way to undermine congressional reconstruction at every turn. And that's not a high crime or misdemeanor, but it's a sort of act of sort of politically weak president, constitutionally weak president who is sort of standing up against the sort of overwhelming will of the of both houses of Congress, and he was impeached for it. So I think, again, thinking too much in terms of legal formulations here is a mistake. It's really about fitness for office.
One thing I would say in response is, although we don't have the time to debate this, but I would disagree entirely with the notion that President Johnson's conduct doesn't rise to the level of being a high crime or misdemeanor, because I believe in the end, high crimes and misdemeanors is about defining constitutional norms, both past and present and future. And I think that there are moments in the history of this country, they're rare, but I think they happen, when the executive branch and the legislative branch confront diametrically opposed visions of the nation's constitutional future, and that when they are completely at loggerheads, as they were in Reconstruction, that in the end, if the matter is of sufficient consequence, that I believe impeachment gives the legislature the power to make that choice. And I think their failure to make that choice, in the case of Andrew Johnson, at least contributed to the failure of Reconstruction and the rise of Jim Crow. Certainly not the only factor by a long, long, long way. But I think it was a constitutional mistake, and I think indeed Andrew Johnson did commit high crimes and misdemeanors, but that's a debate for another day.
I think it's all been said.
Thanks to all the panelists for speaking with us today. My question is with regard to the exposure of the Vice President, Secretary of State, and Attorney General as it relates to the Ukraine affair, if any of you could speak to that.
Okay, in reference to the Vice President, Secretary of State, and the Attorney General's involvement with the Ukraine affair, how does that affect the impeachment proceeding broadly, I guess?
I guess I'm not totally sure I understand the question, but all the cabinet members can be impeached and removed. So the process of impeachment applies to judges, applies to the president, vice president, and the cabinet members. So I think the focus will remain on Trump and not on the others. But if your question was, can anything happen to them? The answer is yes, they can be impeached and removed, and if they committed a crime, they can later be convicted. Tried and convicted. Was that your question? Oh, good.
All right. It's my understanding from the history of impeachment, even going back to Andrew Johnson, someone who was pretty much universally disliked and still made it through the impeachment process without being fully convicted, that there's a strong incentive to stick out the impeachment proceedings, and historically we see that everyone makes it through the impeachment proceedings, with the exception of Nixon. And I know that kind of changed with the discovery of the smoking gun, the tapes, and the defection of his party support to the other side. I was wondering perhaps what you guys thought the political risk was of the Democrats bringing impeachment proceedings, knowing in this type of environment they have a very low chance of removing him, especially in light of, I understand, after Clinton's impeachment, the Democrats picked up seats in the legislature in the next election. I was wondering, especially people who have been involved in some of these controversies in government before, what your perspective was on that.
Anybody?
Well, I think it was a reluctant step. This has been going on for a while. I think that's the other reason why the procedure may seem truncated, but you have to look at it in the context of what had happened before with respect to Russian interference in the election and allegations about that, which were actually proven by the Mueller report, even if the technical legal requirements and obstruction is very difficult to make, as the prosecutor over here would note. So I don't think it was a precipitous move. I think they felt that they had to make a stand because it wasn't going to, it reminds me of toddlers. I've had little children, and you tell them 4 times after you've told them you have 3 chances. And you have to make a consequence. And also, I agree with Professor Bowman that this is it wasn't simply what happened with Ukraine. I've been talking about this. In 2015, it was well known in the Washington Post that the Russians targeted high-level people inside the White House. We've been at cyber war with the Russians for a long time, even in the Obama administration. So, and that's something that many people care about. They care about our foreign relations. Look at what happened with the Republicans in Syria. They appear to care about Syria. So, this is a principled position. It may actually not be a very good thing politically for them. But of all people, I was reading Nancy Pelosi as basically just having said 4 times to the toddler, no, no, no. And now we have to do something. So she's been dragged there against her will, in my estimation. So she knows there could be a political cost, but there is a big difference, as Professor Bloch said, between Clinton and this. Because, as I said, this is more of a self-impeachment situation where the gravity is widely shared by people, even if they like the particular president. So it seems very different in that sense than the Clinton situation. And she's betting on the fact that people will actually pay attention to this, right, and pay attention to the underlying issues. And that, as I said earlier, is a problem of communication. And whether they can do it simply and clearly and not drag it out will be very, very important in terms of having the political consequences. The simpler, the clearer the offense is, the easier it is for the American public who are not trained as lawyers to understand. This was theft. You stole Americans' money. You aided our enemies, basically.
One other point, in addition to what Professor Nourse said, remember that if Trump gets impeached and removed, it's Pence who comes in. So, it's not a change of party, and it's It's the vice president. So it's that may actually help the Republicans politically in some way.
On that point, actually, though, just tying that into the previous question, when this is all over, one thing one thing I would suggest we all think about is rewriting our presidential succession statute. So right after the vice president, who is next in line to succeed is a matter of statutory law, not a matter of constitutional law. Until the 1950s, it was the Secretary of State. In the 1950s, it was changed to be the Speaker of the House and then the President pro tem of the Senate. One problem that the Democrats are facing right now is that they really can't go after Pence too much. Right? Because if they go after Trump and Pence simultaneously, no Republican is ever going to come on board. Right? So if they want to have any chance that the Senate is even going to think about convicting Trump, they have to make Pence sacrosanct. Right? It makes a lot more sense to have a presidential succession regime where the cabinet is next in line because the cabinet is always from the same party as the president. And so that's something we really ought to think about once we get past whatever.
And as Josh just said, that is how it used to be. It used to be the cabinet. And then they thought, well, no, these cabinet officials are not elected, so we should go to someone who's been elected by the people. And that's when they went to the Speaker of the House. But I agree. I think it just looks awful to see the Speaker of the House getting rid of the president when she's next in line. Not next in line, but almost. So I think we should go back. There's no good answer, but I think they had the better answer years ago.
I think we're going to have just one last question. Right here.
Hi. I was hoping any of you could speak a bit about enforcement and compliance. Overall, it seems that there's been this general sense of the executive branch sort of snubbing subpoenas, saying sometimes do your worst if you hold me in contempt. How do you see this process going forward when they meet those roadblocks, potentially overcoming them? I know Professor Chafetz has written a bit about potentially playing hardball, but how that's going to play out both on the Hill and in the public opinion as well.
What I would say, I suppose, is this. I think that given the Democrats have one huge disadvantage here, and it's time. Okay, not only is President Trump, coming to the end of his first term, more important, the Democrats are thinking about the fact that they've got a presidential nominee to select, and they want the country to be paying attention to that. For a good long time before the election. They want the ability to frame the election as something other than, a question about impeachment, and therefore they recognize that if they're going to impeach this guy, they need and balance that with their other imperatives. They've got to do it relatively quickly. That means that a strategy of delay and obstruction is likely to be quite successful for the president and for any of his minions who are willing to go along with that, because the options. I mean, the options are if they don't show up in response to subpoena, A, you can try to hold them in criminal contempt, which means that you got to refer it to the Department of Justice, which under Barr is not going to do anything about that. You can try to sue them civilly, which is fine. You're probably going to win, but it's going to take a long time. And the Trump people are going to make you go all the way up to the Supreme Court, or at least get up to point of denial of cert. You can try to actually have the House Sergeant at Arms arrest somebody and stick him in the basement. But as cool as that sounds, all right, I mean, it's just comic opera, frankly. And you got to remember, and as funny as it sounds, also you got to remember that could take a really ugly turn. All the people you'd want to arrest have guards with guns. And I can imagine unpleasant accidents occurring. Nobody wants that. And the final thing, of course, is that, and I think the Democrats are plainly setting Trump up for this. On the one hand, they're actually getting a tremendous amount of information out of people that I would say are tremendous Americans who are coming forward despite the Trump administration telling them not to. They're getting a lot of information. They're going to get enough to make a really, a succinct case. But Trump, on the other hand, is so blatantly obstructing. He's also creating a separate article of impeachment for obstruction of the House investigative process, which was Article 3 in the Nixon impeachment, voted out by the House Judiciary Committee. So that's where it's going to go. They're going to get as much as they can. They'll litigate to the extent they think is felicitous, and in the end they'll impeach him for both substance and obstruction.
Does anybody else have anything to add, or? Okay, well, thank you so much to our panelists. I just want to invite everyone to a reception, which is held directly outside in the lobby, to maybe talk with some of our panelists or to meet each other. Thank you so much.
So do you think
So much. It's lovely to